Hello, a warm welcome to you from STT University. I'm Anjali from Faculty of Law. Today we are going to learn about de facto and de jure recognition.
Modes of recognition. There are two modes of recognition of a state: de facto recognition and de jure recognition. By de facto recognition, we mean a provisional recognition of statehood. It is a primary step to de jure recognition. It is a temporary and factual recognition as a state, and it can be either conditional or without any condition. This mode of recognition is granted when a new state holds a sufficient territory and control over a particular territory, but the other existing states consider that it does not have enough stability or any other unsettling issues. So, we can consider it as a test of control for newly formed states. De facto recognition is a process of acknowledging a new state by a non-committal act. The states having de facto recognition are not eligible for being a member of the UN, example Israel, Taiwan, Bangladesh. De jure recognition. De jure recognition is the recognition of a new state by the existing state when they consider that the new state fulfills all the essential characteristics of a state. The de jure recognition can be granted either with or without de facto recognition. This mode of recognition is granted when the newly formed state acquires permanent stability and statehood. The de jure recognition grants the permanent status of a newborn state as a sovereign state. In the case of Luther versus Sagor, it was held that for the purpose of giving effect to the internal acts of the recognized authority, there is no distinction between de facto and de jure recognition. Examples of de facto and de jure recognition. One of the examples of de facto and de jure recognition is the recognition of the Soviet Union was established in 1917. It was the de facto recognized by the government of UK in 1921, but it was not given the de jure recognition until 1924. Similarly, Bangladesh was established in March 1971. India and Bhutan recognized it just after 9 months of the establishment, but the US gave its legal recognition after nearly a year in 1972. Let us now look at the distinction between de facto and de jure recognition. De facto recognition is a provisional and factual recognition, whereas de jure recognition is a legal recognition. De facto recognition is granted when there is fulfillment of the essential conditions of statehood. De jure recognition is granted when the state fulfills all the essential conditions of state along with sufficient control and permanency. De facto recognition is a primary step towards granting de jure recognition. De jure recognition can be granted either with or without the grant of de facto recognition. De facto recognition can either be conditional or non-conditional, whereas de jure recognition is final and non-conditional. De facto recognition is revocable in nature. De jure is non-revocable. The states recognized under this mode have only a few rights and obligations as against other states, whereas in de jure recognition, the state enjoys absolute rights and obligations against other states. Under de facto recognition, the state cannot undergo state succession, whereas under de jure recognition, state can undergo state succession. The state with de facto recognition cannot enjoy the full diplomatic immunities, whereas under de jure recognition, state enjoys complete diplomatic immunities. When a newly formed state is recognized, its declaration can be made in two forms: express recognition and implied recognition. Express recognition: when an existing state recognizes a new state expressly through official declaration or notification, it is considered to be the expressed form of recognition. Express recognition can be made through any express or formal means, such as sending or publishing a declaration or a statement to the opposite party. When a state is recognized by expressed ways, it is a de jure recognition, unless provided otherwise by the recognizing state in that declaration. Second is implied recognition. When the existing state recognizes a newly formed state through any implied act, then it is considered as an implied recognition. By implied recognition can be granted through any implied means by which a current state treats the newly formed state as an international person. The implied credit not granted through any official notification or declaration. The recognition through implied means varies from case to case. There is another form of recognition known as conditional recognition. It is a recognition of state with which certain conditions are attached in order to obtain its status as a sovereign state. Is conditional recognition. The conditions attached varies from state to state, such as religious freedom, rule of law, democracy, human rights, etc. The recognition of any state is already associated with the essential conditions to be fulfilled for the status of a sovereign state, but when addition condition is attached to it, it is called conditional recognition. Criticism. Many jurists criticize conditional recognition. The conditional recognition is criticized on the ground recognition is a legal procedure and no additional conditions should be attached with it other than the conditions recognized by law. Another reason for criticism is that the recognized state, if it does not fulfill the condition attached for its recognition, recognition is not extinguished and it should still be valid. After doing the forms of recognition, let us look at the withdrawal of recognition. Withdrawal of de facto recognition under international law: when a state having the de facto recognition fails to fulfill the essential conditions of statehood, its recognition can be withdrawn. The recognition can be withdrawn by the recognizing state through declaration or through communicating it to the authorities of the recognized state. The withdrawal can also be done by issuing a public statement. Withdrawal of de jure recognition. Withdrawal of a de jure recognition is a very exceptional event. If strictly interpreted, the de jure recognition can be withdrawn. Even though the process of recognition is a political act, de jure recognition is of legal nature. Jurists who consider de jure recognition as a political act considers it revocable. Such revocation of de jure recognized states can be withdrawn only when a state loses the essential characteristics of a statehood or any other exceptional circumstances. This type of revocation can be done expressly by the recognizing state by issuing a public statement. In the end, we can conclude that the recognition being either de facto or de jure, it provides rights, privileges, and obligations. When a state gets its de facto recognition, the rights, privileges, and obligations are less, but when it is recognized de jure, it gets absolute rights, liabilities, and privileges. The recognition of the state is too much politically influences on the international platform. There have been many instances where the powerful state create obstruction in recognition of a newly formed state.
So, today we learnt about de facto and de jure recognition and forms of recognition. And the next time we meet, we will be exploring about law of sees. Till then, keep learning, keep growing. See you next time.